Hey guys, so good morning everyone. Thanks for being here. As you all know, we have a very special guest today. I think coming down from Kingston, where he's currently residing, Brigadier General retired now, Kenneth Watkin, who served for 33 years in the Canadian Armed Forces, 4 years as the Judge Advocate General, the Senior Military Legal Advisor and Superintendent of the Military Justice System. As a military legal officer, he worked in a variety of operational military justice and general legal advisory positions, including being responsible for the provision of operational law advice in respect of Canada's air, sea, land, and special forces operations following the 9/11 attacks, first as the Deputy Judge Advocate General Operations and then as the Judge Advocate General. Ken has published extensively in the areas of humanitarian law, human rights law, and Canadian constitutional law, with articles referred to by the Canadian and Israeli Supreme Courts, amongst others. He's also participated as an expert in international working groups tasked with clarifying the law as it applies to contemporary armed conflict by developing manuals dealing with cyber warfare, occupied territory, air and missile warfare, and direct participation in hostilities. Since his retirement from the Canadian Forces in 2010, he served as a foreign observer to the Israeli Independent Commission investigating the May 31st, 2010 Gaza blockade incidents, and from May 2011 until June 2012 as the Charles H. Stockton Professor of International Law at the United States Naval War College. Ken is a graduate of the Royal Military College of Canada and Queen's University, where he went to law school in Kingston, Ontario. He was appointed Queen's Counsel by the Lieutenant Governor in Council of Newfoundland, Canada, in 2006, and he was also appointed by the Governor of General of Canada to the Order of Military Merit in 2002. As you all know, today he'll be presenting about his latest book, which I believe was published last summer by the Oxford University Press, called Fighting at the Legal Boundaries, Controlling the Use of Force in Contemporary Conflict. This talk today is very generously sponsored by the Nathanson Center here at Osgoode Hall Law School. So thank you, and thank you for coming today.
Okay, thank you very much. Problem with great introductions like that is they always make me feel a little old. Anyways, there you go. Can we have the first slide there, and we'll... Okay, just gonna watch my time here. All right, so I'm going to talk today about the changes and stresses the international law is under, because that's fundamentally what my book is about. So I thought I'd start with a quote from President Obama, and under that, a quote from President Trump. Never thought I'd say President Trump, but there you go. But notice the difference of the tenor between the two quotes, right? One's talking about restraint on the use of force, and the others talk about eradicating radical Islamic jihads. The thing to put this all in perspective, however, is both of these approaches are very much at a different end of the spectrum where large parts of the international law community are, particularly in Europe. Because the US approach, even under President Obama, it's much more aggressive than many international law scholars believe it should be. And the question is how law is changing over the last 15 years. And that's sort of what I experienced in my time in dealing with operational law issues, is the stresses that international law has been under. So I'm going to start out, though, with a quote from Sun Tzu, the Chinese military philosopher. If you know the enemy and you know yourself, you need not fear the result of 100 battles. The question is how well we know the enemy and how we describe the enemy, and how well we know ourselves in terms of how we're addressing that threat. And I think this is the genesis of what the tension is in international law. So the lecture will look at this, and I will be discussing the enemy as an insurgency. And many of you, I think, will think of the enemy as simply terrorists. And they have this dialogue going on. The two are quite different in terms of their effect, their goals, and the impact they have on us trying to keep our societies secure. This is not 10 men sitting in a cave in Tora Bora trying to figure out when to launch the next attack on the continental United States. This is a significant insurgency which is transnational. And one of the other challenges that happens in this is there's an old saying, you can't win an insurgency by killing, and you can't win an insurgency without it. And there's an inherent tension that comes up between international humanitarian law and human rights law in terms of how you deal with this threat. And in doing this, we'll look at drones, targeted killing, and collateral damage. Ultimately, what will be argued is there's a need for a holistic response, and that international law has been, in many respects, continues to be too compartmentalized in terms of how international lawyers interpret the law to deal with what is a unique threat, one that it wasn't designed to deal with. In other words, as a military legal advisor, I found myself applying 20th century law to a 21st century enemy. And so how do we get from the 20th century into the 21st century and keep close and dear to us what we need to keep our societies both safe and just, right? Next slide. So this is the jihadist 5-year plan. They aren't there yet, are they? And indeed, are they ever going to get there? But this raises the question of what is an existential threat? This goal is definitely cross-border. Is it global? Not suggesting we have a global war on terrorism. But neither, as I said, is it 10 guys in a cave trying to figure out when they're going to have their next terrorist attack against North America or Europe or any other part of the world, right? And so is this the Trump nightmare? And from a Canadian perspective, why are we involved? Is this an existential threat to Canada? If you certainly lived in Israel, if you lived in the south of Spain, if you lived in Greece, if you lived in the Balkans, part of Europe, you would see this as a threat. Why do we care? We lose many more people per year. You don't get many of these lectures and someone will say, we lose so many people in car accidents compared to what we've lost to terrorism. Why do we care? It's overseas. Why do we care? But it raises some fundamental issues of what we view as existential. When we're part of a global economy, when we're linked to these countries, when we view rights and the people that are being abused by what are some very horrific groups, it's some big challenges in terms of what we see ourselves needing to react to. So jihadists are an exceptionally small faction of Muslims. One of the challenges that you have when you start to look at this area is even trying to get statistics, right? So what I've been able to determine is, and this seems pretty consistent, there's 1.5 to 1.6, 1.57 actually, billion Muslims, 23% of the world population. Around 90% are Sunni, 10% are Shia, two factions, right? Sectarian. There's extreme diversity, as you all know, within the Muslim community. There is a very small part of the Sunni sect, right, which are Salafis. And even within the Salafis, there are 3 streams. There's a quietist stream, there's a political stream, to which the Muslim Brotherhood is quite often connected to, although depending on what you read, whether they're part of the Salafi sect or not, depends on the analyst, I guess, and how close they are. And then you've got the jihadists, the true radical conservative fundamentalists, of which Al-Qaeda and the Islamic State are the poster groups, right? But there are many more jihadist groups than those two. So if you were trying to figure out statistically, someone said it's less than 1%. Well, 90% of 1.6 billion Muslims is 1.4 billion. Less than 1% is what? 14 million Islamic jihadists? There's no way there's that number. So I found another Israeli Shin Bet retired officer said it was 0.01%. Well, that's 1.4 million. There's no way there's that many. The reality is we don't know, right? And people are just taking stabs at the dark. But if you look at the numbers in terms of what's said in terms of the enemy forces, the Islamic State last year was put at about 35,000. Al-Shabaab is about 5,000. AQIM, Al-Qaeda in the Islamic Maghreb, in North Africa, a couple thousand. Right? These are very small numbers, but with tremendous impact on world affairs, as we're seeing daily in the newspaper. Right? And this group, the radical jihadists, are genocidal. They are rapists. They take sex slaves. They fight against, there's an intersect war in the Muslims, between the Shias and the Sunnis. Tremendously radical I would say, evil group that needs to be confronted, that is causing turmoil, obviously in particular in certain regions of the world, but on a global scale it's causing turmoil, as seen in North America or Europe by the terrorist acts that they do. So they're Islamic groups that carry out terrorist acts, right? The other thing is that they have their own doctrine. So rather than these 10 guys, as I say, you know, sitting in a cave, these are guys that have, one in 2005, Abu Musab al-Suri, talked about open fronts, which are conventional type warfare, secret confrontations, which you would think of as guerrilla warfare, and talked about individual jihad and small cell terrorism. We would call that lone wolf terrorism. So the jihadist groups are following their own doctrine, very much the way military forces for states have their own military doctrine, right? There's another one, a practical guide course for guerrilla warfare that was written in terms of telling the jihadist small cell groups how to operate. Another group, of which is particularly important to the way the Islamic State operates, is a doctrine manual called The Management of Savagery, the most critical stage through which the Ummah will pass, 2006. So there is a game plan to which these jihadist groups are following. And we should be concerned. And they follow the Maoist revolutionary warfare, and you can find it in their doctrine, where it starts out with low-level crime, terrorism, works its way up to guerrilla warfare, works its way up to conventional operations. And if you look at what happened with AQI, Al-Qaeda in Iraq, and see what it did in 2013, 2014, 2015 to the present day, you can see that growth up to almost conventional type armed force, right, that seized territory, that wants to set up a caliphate. A very sophisticated enemy that at times can beat us. There are very, very smart people, just like we have very, very smart people. They have some not so smart people, we have some not so smart people, right? It's two groups of humans fighting one another with different capabilities and different approaches. And like all guerrilla warfare, once they're beaten down from the point where they can control territory, they will revert to fighting in the shadows. And so you have this battle again of what happens when ISIS is defeated in Mosul. What happens when ISIS is defeated in Raqqa, and how do you eradicate Islamic terrorism from the face of the earth, which is what President Trump wants to do? A significant, significant challenge. Next slide. So this is the jihadist reality. But things about that, it's a smaller footprint, but one of the key things about jihadists is they simply do not recognize borders. This is a challenge for international law and its state-based notion of how we should order ourselves in society, right? So this is what one of their doctrines says, al-Suri's. Islam pays no heed to the borders of the Crusaders. The Crusaders drew up between our countries and nationalities, citizenship regimes, and the passports they invented. So this may not be a global war on terrorism, but it's definitely a transnational armed conflict. It doesn't just happen exclusively within the borders of individual states, although it does happen within the borders of individual states. And the question is how international law reacts to that. The King of Jordan said the following recently in September 2016. I think the problem with the West is they see a border between Syria and Iraq. Daesh, which is the pejorative name for ISIS, does not. And this has been a frustration, I think, for a few of us in this area with our Western coalition partners for several years. You know, the lawyers get into the act and say, but there's an international border. And we say, for God's sake, ISIS doesn't work that way, he said. So it's a challenge, isn't it, in terms of particularly dealing with these threats. That was, I believe, from a 60 Minutes program. It was reported in The Hill in 2016. So it highlights a problem for international law and lawyers, because how do we look at things? We are exceedingly state-based. We have borders, we draw those lines in the sand, and there's sovereignty, and you better not cross them, right? Or you've breached international law. Well, with a few exceptions. And so in many respects, what the arguments are about are what the exceptions are in terms of when you're allowed to cross or not cross borders in order to take out military action. One of the challenges for international lawyers for international law is it has become extremely formalist. Really, really driven by borders and sovereignty. And what it doesn't address enough is the notion of ungoverned spaces. Because if you're a state and you're responsible for borders, it means you exercise control within those borders. But what happens if you don't? What if it's an ungoverned space and a group can operate within that space? Let's say the management of savagery, that their goal is to operate from that space and attack another state. What can the other state do is the challenge. So just 3 examples. I want to start off with Mali because there's a lot of talk about the Canadian forces going to Mali, right? And who knows where we're going to end up after the most recent discussions are between the US and Canada. And there's a lot of talk about Mali being a peacekeeping operation. So let me be clear. It is not United Nations peacekeeping in fact, in doctrine, or in law. It is a Chapter 7 UN-mandated operation against Islamic jihadist groups operating largely in the north of Mali, but not exclusively. It is an armed conflict. There are regularly improvised explosive device attacks against the UN peacekeepers there. 110 peacekeepers have died since the mission started. And there was just one a couple of weeks ago with suicide bombers. This is an armed conflict. It's not, peacekeeping is Chapter 6. The war's over. 2 sides have agreed to come together. It's not even close from a doctrinal perspective. So it's a challenge to call it UN peacekeeping. And the challenge for the military and other groups will be ensuring they have the right rules of engagement to allow them to react to that in terms of what is really a very capable enemy. We may not view ourselves at war with them. They definitely view themselves at war with us. Challenge, isn't it? Okay, then we have Jihadist Central, Syria. So there, 400,000 have been killed, 408 million refugees, many more million internally displaced persons, 1.1 million asylum seekers in Europe. You know, we have taken 25,000. That's very good on us. I'm involved with a group that's sponsoring a Syrian refugee family. Very good on Canada. It's a drop in the bucket compared to what the region around Syria is facing, right? The Syrian military, 150,000. They have another 150,000 of paramilitary organizations, loosely disciplined, organized, controlled. Russia, Iran, Hezbollah. There are specific Shia brigades made up of volunteers from Afghanistan and Pakistan. The enemy, diverse rebel groups. There's 150,000 rebels in 1,500 armed groups. And generally what you hear about in the media is the Islamic State and Al-Qaeda. And Al-Qaeda keeps changing its name, keeps rebranding itself, right? So they're smarter than us. They keep changing the dialogue. Okay, then you have the Syrian Kurds, and then you have the regional actors, Turkey, Israel, Lebanon. The coalition actors, United States, United Kingdom, France, Australia, Saudi Arabia, Turkey, Jordan, the UAE. Is Canada involved in the fight in Syria? We're involved in the fight in Iraq, but that's because we recognize the border, right? The enemy doesn't. Challenge. Okay, and we have Iraq, where Canada is involved, right? Canadian participation, we were involved in bombing in Iraq. The new government came in, withdrew from the bombing, but are we still involved in bombing? Well, we're refueling bombers, right? The Germans took a similar approach. They were refueling bombers, and then the first day they refueled a bomber, a German newspaper had a headline, "Germany undertakes its first airstrike." Right? Because they're taking a direct part in hostilities. We have special forces that are launching anti-tank weapons at, as reported in the news, at the Islamic State fighters to protect Kurdish civilians and the Kurd people they're advising. Is that involved in armed conflict? I'll leave it up to international lawyers to determine that, right? So, the next slide. Here's one of the challenges, is for all that we're going to talk about how complicated conflict is, and that's sort of Syria in particular, is they call it jihadist central, right? It is probably the most complicated conflict because in the midst of this you have the Shia-Sunni battle, tremendously. You have the Kurds, you have the US trying to support groups that Turkey wants to fight. Turkey has intervened in Syria and Iraq without the permission of either of the governments. The US special forces are operating in Syria, and Syria has now said, okay, they can do it as long as they coordinate with us. Is that going to happen? And Russia, of course, has intervened in Syria. This is a powder keg waiting to go off, right? Big, big challenges. And so this is the best we can do, binary. And we have conventional armed conflict, state on state, tanks fighting tanks, airplanes fighting airplanes. We have guerrilla warfare, people hiding in the shadows, attacking the states. And so the new term is hybrid warfare. So this is from a doctrinal perspective, everything's hybrid. So in Crimea, the Russian special forces with no marks and everything, little green men they called them, that's hybrid warfare because it didn't involve conventional forces. A cyber attack, that's hybrid warfare because you're using computers and not just airstrikes. And it's not just that, because hybrid's also used in terms to describe the guerrilla groups, right? So Hezbollah is a hybrid organization. It has a small regular armed force and a large sort of militia type force that it uses. The Taliban is similar. They have their special regular groups that come across from Pakistan, and then they recruit the locals to help them fight in the local area, right? So this hybrid organization. From a legal perspective, we're far more sophisticated, right? I wish it was true, because what we get hung up on as international lawyers is we get hung up on it's either the law of armed conflict or international humanitarian law, or it's human rights. And never the two shall meet. There has been a tremendous strategic battle between these two communities. Tremendous battle. So you have state armed forces, the US in particular, Israel, sees no room for human rights law on the battlefield. You have human rights groups and human rights advocates and a number of law professors that see no room for the law of armed conflict and internal armed conflict. It's all just human rights. The challenge is that isn't the way it works on the ground. It isn't even the way it works at law. International humanitarian law is filled with human rights notions. Geneva Convention 4 is a human rights document, fundamentally. Article 75, AP1, incorporates basically the provisions of the International Covenant on Civil and Political, the ICCPR, right? Rights. But there's this not just academic debate, it's a state debate as well in terms of the two not getting along with one another. We like to live in this binary world. Again, the problem is that isn't how it works. And the debate you'll see talked about is the lex specialis. So the first thing the international lawyers will bring out is Latin, right? Because we want to communicate with people. I mean, I don't know where else in the legal community that we use Latin other than in this group, right? Lex specialis. But the other two are jus in bello and jus ad bellum, right? Jus in bello, law in war. Jus ad bellum, going to war, state self-defense. When were those terms created? If I told you the 1920s and the lead up to try to restrict after World War I, bring back in the notion of a just war type of restriction on the use of force, there's some good theories that that's where it was first developed. Okay? Give it a Latin aura and it sounds like it's real. Okay, but if you're communicating with people, it's a challenge, right? So I just put that out. I try not to use those terms, and I won't today. Okay, so next slide. So here's the challenge we have, is the two types of warfare. So on state conflict is largely conventional warfare, right? It's got some guerrilla warfare, and it's got some crime issues it's got to deal with, particularly when you're an occupying power. Iraq was a big sign of that, right? On your left, you have the other type of warfare, irregular type warfare, which has some conventional. So if we use the Islamic State, a lot of crime, guerrilla warfare, and some conventional operations. Which is the predominant form of warfare? The one on the left. Which has always been the predominant form of warfare? Irregular warfare. Which is the form of warfare which is the most highly regulated? Not just the one on the right, all the way up to the top. Conventional warfare, right? So if you want to find a treaty, you got it. The Geneva Convention, they're there, right? There's a ton of conventions. What about the one on the left? It's a challenge. Now, some of this is for very good reasons. States are capable of tremendous violence, right? 50 million people in World War II. 20 some odd million people in World War I. States kill people. They need to be regulated. And that's the basis internally of human rights, right? To stop the control of states over their own people. Stop what they're doing to their own people and regulate it. Internationally, the controls are more of the law of armed conflict between states, right? And so, as we'll talk about in a bit, it has more accepting rules of violence because, quite frankly, interstate conflict is more violent. Armed conflict is more violent than internal conflict normally, or internal peace. So this is one of the challenges we have. The challenge, though, is if the majority of warfare is on the left, where's the majority of the effort should go? If you're going to fight an insurgency, there has to be primacy of law enforcement. Because the reason you have an insurgency is a lack of good governance. You cannot kill your way to winning an insurgency. As I said starting out, there's that old saying, you can't win without it, however. Because some of these organized armed groups are extremely capable, right? Like ISIS, for instance, or Al-Qaeda. The other piece that's interesting is Al-Qaeda, I'm going to suggest to you, is a far more dangerous armed group than the Islamic State is. Far more dangerous. Because how Al-Qaeda operates is from the bottom up. The Islamic State imposes from the top down. So the Islamic State's not around very long until the people start to chafe against the type of restrictions that they put on it, or those types of jihadist groups. So when AQIM came into Mali, they went into the Tuareg. They were initially allied with the Tuaregs. They couldn't stand how vicious they were, right? They were happy to move them on when the chance came along and the French intervened. Al-Qaeda goes like this. We're very accepting of you. Come fight with us. And then we will move forward and then increasingly bring in our way of how we want to govern. They're a far more dangerous group. There was a Pakistani journalist that wrote a book back in 2009 that described just this, which was the notion of, it's about the drone debate, the drone fight. I call it bright, shiny object law. So around 2009, 2010, 2011, right, where quite rightly everybody was looking at drones, okay, the US was relying on drones to say we are deteriorating the enemy. We're succeeding. So this is what the Obama administration was first saying, right? Human rights groups looked upon it the same way in a way because drones were being used against small groups of terrorists. Only their argument was you shouldn't be using drones because this is a law enforcement matter. We'll talk a bit more of this in a second. And Al-Qaeda was happy to say, have at it. Because we're expanding everywhere else. Because we are linked. And so at that time there was this debate about things called the leaderless jihad, all that type of debate was in reality, there is many diverse groups with a common cause. Okay. Next slide. So, these are all the areas of law you need to know when you're giving advice on operations. It's far more than the law of armed conflict. The problem is, from a 21st century perspective, the 20th century has all these bodies of law not talking to one another. So if we were back in September 10th, 2001, the vast majority of international lawyers would say there's no right of self-defense against a non-state actor. Only if the non-state actor is being controlled by a state can you go attack that non-state actor. Otherwise, it's the state's responsibility where the non-state actor is hanging out. Okay, you can't mix the law of armed conflict and the right of self-defense, right? Because we don't want the justness of the cause to apply to how you apply the body of law to the two enemies. Get that 100%. But does that mean they're never connected? What if you act in self-defense? What are the rules governing the use of force? Are they the law of armed conflict? Are they human rights law? Or are they something different? Well, if you haven't discussed this, you've got a challenge, right? And one of the challenges you have to have is you have to have an armed conflict for the law of armed conflict to apply. So when does an armed conflict start with a non-state actor? The international community went, oh, well, it's a very high threshold. Well, then what does that mean? You can only use law enforcement means, and many groups say yes. The problem is that may not match the threat you have, right? It's a challenge. Okay, so international human rights. There's a strong body of law that looks upon human rights of just having started after World War II. Right? So the Universal Declaration, the ICCPR, all those rights. And they don't discuss domestic human rights. But clearly there are domestic human rights. The rights of man, the Bill of Rights. These were all notions that went far beyond the borders of the countries that they were developed in. Right? A challenge. And then, of course, there may be some international criminal law students in the crowd. It's the most mingled. It includes both human rights and humanitarian law concepts, clearly. But how about this domestic court versus international court thing? How's that working out? Well, clearly, the ICC is getting some pushback, but in any event, the ICC was never going to deal with all the crimes that are being committed in Syria. Right? The vast majority of these crimes are dealt with by domestic tribunals, although there are some blended tribunals. There's different ways that that's done. But just the number of crimes makes it a challenge, right? In terms of how do you make all these work together. So let's talk about drones for a second. So there were three approaches to drone warfare. One is the restrictive law enforcement approach, which I've already talked about a bit, which is you take the view that you can only use self-defense against another state, right? That all these are criminal groups. The violence is periodic. It never reaches the threshold, right? What's the threshold for a non-international armed conflict? TADIC, protracted armed violence by organized armed groups, to which they added intensity. And the question is, how protracted, intense does it have to be? How organized does the group have to be? That case was decided in a European setting with a conflict that was already going on in Kosovo. What about Mumbai, 2008? What about the Westgate Mall? What about Paris, 2015? Were those acts simply the acts of criminals, or were they part of an armed conflict? And was the violence intense enough that the state could act in self-defense and use military means using armed conflict rules to respond? Those are the types of real-world questions that international lawyers, both academic, state, and military practitioners, are trying to deal with. But the other approach was the permissive approach. So the American approach was, well, we're going to borrow from neutrality law. We're going to take the view that if you're unwilling or unable to look after your territory, we have a right to intervene to stop it. Right? And we will take a very broad view of imminence. So we don't have to actually know you're doing it. You people are planning attacks all the time. So we will strike. So we will strike in Yemen, we'll strike in Somalia. This is away from what they now call active battlefields, like Afghanistan, Syria, right? It's in strikes in Pakistan, Yemen. So this is basically the involvement, one of the theories for the US strikes on drone strikes. It's sort of an armed conflict follows the person you're striking. They're part of the organized armed group, they're planning, and you can cross the border because unwilling and unable. So unwilling and unable is a new term, right? In international law. Sorry, it's not. I found it in 1958, D.W. Bullitt. Unwilling and unable gives you a right to intervene to look after your nationals. What's the alternate of not being able to intervene? it puts you in a situation of having to react all the time, right? So, you know that old game of whack-a-mole? So you don't go after the source of the attack, you wait for the attack to happen on your territory. That's a dangerous, on one level, it's a dangerous approach because it doesn't give you much time to react, does it? And you see this tension going on throughout the debates in law and how you react to these organized armed groups. Okay, and the third one was a new one, self-defense. And so it was drawn out of the Bush era, and there's two theories. One called naked self-defense, which was put forward because the US government at that time didn't appear to be applying in the theory of its, the professor that brought it forward, didn't seem to be applying law at all. So he said, if you don't have an armed conflict, you have to apply this. So it's almost applying law as policy. The other sort of form of this self-defense comes from a notion of self-defense that is, I call it robust. In other words, I accept what the human rights groups are saying, that it's not an armed conflict because the threshold's so high. So we'll just say under self-defense, we're entitled to do the same thing we would have been able to do anyways, applying the law of armed conflict as a matter of policy. There you go. Those are the three theories out there for drone warfare challenge. The second one was being able to intervene to protect your nationals. Think hostage rescue, right? And so the large number of the jihadist groups certainly fund their operations through taking hostages, right? Getting the money, and it's big money for the jihadist groups. But a lot of these areas happen where there's just a lot of crime, right? The vast majority of hostages taken in Iraq appear to have been taken just by local criminals in terms of getting money within Iraq. Sometimes they're taken by local criminal groups and sold or transferred to the jihadists. Raises some interesting challenges over which body of law you use when you're trying to protect your nationals, right? Or you can have the Maersk, Alabama, 2009, off the coast of Somalia, international waters, where the US SEALs parachuted down to the ship, into the ocean, picked up by the ship, and you saw the movie Captain Phillips, right? Killed the 3 criminals. Was that human rights law that was governing their use of force? Sure, it was, right? Because the Somali pirates generally weren't involved with the Al-Shabaab. It was criminal activity. But you can act to defend your nationals. So, there we go. One of the challenges with all this is they all have a just war basis. Right? Now, we talk about just war anymore. It's all been secularized, right? Because just war has a sort of Judeo-Christian sort of background to it, Christian background to it. Okay? And we don't use that terminology anymore. But think of the responsibility to protect, the doctrine that came out in 2001. When you look at the factors that are applied for the responsibility to protect, they are the very same traditional factors that are applied to just war doctrine. Exactly. Because that's what the UN Charter represented, was a reinstitution of just war doctrine, particularly with stopping states to go to war. Okay, next slide. Direct participation in hostilities. So, if you were a legal advisor, September 11th, 2001, and you asked the question is, if this is an organized armed group, Al-Qaeda, that just attacked us, and we are responding with the rest of the world, including not only invoking our right to self-defense, which was recognized, the right to respond to self-defense was recognized in the UN Security Council resolution, or invoking Article 5 of the North Atlantic Treaty, who can we kill if we have to? Okay, and this is the law. Not much there, is there? So there's 2 groups you can kill, right? Enemy soldiers, lawful combatants, or civilians who are taking a direct part in hostilities. Remember I told you too much of international law is just binary? This is binary. And there's also an influence, a just war influence. Because the only way you can be a lawful participant in warfare is to fight for a state. If you don't fight for a state, you're unlawful. What means you're a criminal. which now raises the question, can you be dealt with under international humanitarian law, or do you have to be dealt with under human rights law? Right? And the answer is both, if you're taking a direct part in hostilities, right? So but I don't want to apply those two bodies of law. You know, I'm on the ground, but you have to, right? And this is the challenge in terms of trying to operate these laws separately all the time. It's inevitable in dealing with non-state actors, you're going to apply human rights law, and you're going to apply the law of armed conflict if they are a participant in an armed conflict. Okay, so this is the wording from Additional Protocol 1, 1977. Who qualifies as an organized armed group? So the theory goes, combat function. So I can claim some credit for that term. I wrote an article back in 2004 that was in the American Journal of International Law that suggested you should be able to target them if they're caring about a combat function. And the Israeli Supreme Court grabbed that wording and sort of used that. Well, the ICRC had their study, and the fellow that's doing a study did his PhD thesis. For you PhD folks in the crowd, you can have some effect. He got appointed to head the study for the ICRC study, and he came up with continuous combat function. And I went to the meeting and said, damn, that isn't what I said. I just said combat function, right? And so the debate becomes, what does that mean, right? How continuous? And if you aren't doing a continuous combat function, what's that mean? Well, the ICRC came up with some other terms. It had to be one causal step away from the action, whatever that means. And there could be a revolving door. What does that mean? Revolving door is actually a pejorative term that was created by an American Air Force officer, Hayes Parks, in an article he wrote about the Vietnam War and the use of air power, where he talked about North Vietnamese shooting and dropping the weapons, and he said at the airplanes, and then picking up the weapons again and dropping the weapons, and you shouldn't be allowed to take advantage of a revolving door. The Israeli Supreme Court said the same thing. The ICRC study said, no, you can have a revolving door. So how many times do you get to go through the revolving door before the soldier says, no, I think I'll shoot you before you come through the door, right? Because it's continuous. And so these are the types of debates that are going on in international circles about killing people. Okay? I mean, this is serious stuff. What should be particularly concerning is we're now into 2009. This law has been around since 1977, and we're just talking about it now as to what the rules are. Because we had a body of law, international law, that was so focused on interstate conflict, right? So things have had to change. And so this is where much of the debate is going on. And what about people who are just providing support? What does that mean? Is it direct support or indirect support? What's indirect support? Is direct support giving intelligence to the enemy? I would argue yes. Is it tactical intelligence? It's reported that during Libya, there was a woman who was in Sealy's Bay, it's just like 40 kilometers north of Kingston, who was getting reports off social media of the location of Libya military things and passing them to NATO, who set up an office to get these reports, and then NATO presumably was putting them into their criteria where you might find the enemy. Was she taking a direct part in hostilities? It's a different world in which we live, right? The debates are, is the cook taking a direct part in hostilities? So if you have a cook that goes with you, is the cook taking a direct part in hostilities? The Army cooks are. They're wearing uniforms, right? Should the cook for an organized armed group? I would suggest yes, if they're part of the organized armed group. The ICRC study would say no. And the debate is this, because if you shoot the wrong person, then you've committed murder, right? Because you didn't have a right. At least that was how the argument goes. And so you have different rules for organized armed groups and different rules for state armed forces. Why? Some real tensions. Okay, next slide. So I'm just going to do a couple of these. You can help me out with these. Osama bin Laden was a lawful target. As one of my American friends used to say, he's a self-nominating target. He shows up in every video with a camouflage jacket and an AK-47, right? Those are easy. Okay, what about the head of a humanitarian wing? Say the head of the humanitarian wing for Hamas or Hezbollah or one of the Taliban groups. Are these groups so sophisticated when they're governing that they're not part of the organized armed group? I think there's an argument they are when you're carrying governance. Depends on the group, right? What if you're the financier for the Islamic State and you're controlling the oil industry? And the proceeds, some proceeds of the oil are being used to fund the conflict, and some proceeds of the oil are just being used to live in Syria with the people you're governing. Are they a lawful target? Some real challenge issues in terms of taking a direct part in hostilities. Canadian fighting for the Islamic State. What bodies of law come in if we're going to target a Canadian fighting for the Islamic State? Well, law of armed conflict for sure, right? Canadian domestic law? You better believe it, right? And this is what happened to the US under Obama. They targeted Anwar al-Awlaki, right? And the question was, the US takes the view that international human rights treaties don't have extraterritorial effect. Well, they've made some exceptions for the Torture Convention, right? The problem they got into was they were targeting one of their own citizens. So international human rights law may not have extraterritorial effect, but the US Constitution sure does, which led to the Obama doctrine, which was to try capture first, consider capture first, only use near certainty as the test that you're going to target, right? A much higher level than under human rights law or the law of armed conflict, right? It's reasonable belief. Near certainty, and then you can use a drone strike. So those were other challenges that come up. Okay, next slide, just to, because there's just all sorts of examples you can go on. Somali pirate. Can you target them under the law of armed conflict? I already gave you that one. They're criminals. Of course you can't. They're not taking part in an armed conflict. Can they be dangerous people? Sure. Might you have to kill them? Yes. In a similar situation as a hostage rescue situation in Canada, right? Or the United States. But at some point, it starts to blend together a little bit. And you see that with military and police forces when they're fighting insurgencies. So one of the debates in the US is the militarization of the police force. Right? But you try to be a police force operating in Iraq and see how much you start to look like a military force because you're trying to survive. You try to be a military force in Iraq and look how you start to take on policing responsibilities because you also have to govern. And the police force may not be capable. The two start to blend together. Okay, let's see, there's one more here. The civilian working at the Islamic State oil production facility. Lawful target? Well, in many respects, they're no different than the World War II factory worker, right? Is how the argument goes. Now, were factory workers targeted in World War II? They were viewed as quasi-combatants. And so one of the big pushes at the end of World War II was clearly they aren't lawful targets. And one of the challenges you have when you're targeting oil, which the US is doing, coalition strikes are targeting oil in a big way, and views that additional Protocol 1 countries wouldn't necessarily agree with, is what about the people that are actually doing it? The people that are doing it are small production facilities, and now sort of mom and pop type production facilities. They've been doing it forever. Okay, it's all part of the underground criminal smuggling stuff that's been going on in that part of the world forever. And now the question is, are they lawful targets? And the argument would be no. I would even argue the production facility, unless you can prove that the production, the oil is actually going to the military forces, could be unlawful. But it also shows how civilians get caught up in these types of conflicts. Okay, next slide. So I mentioned to you about these three theories, and look at this one. So if we sort it out with some level of clarity who takes a direct part in hostilities, even if you apply the RCRC standard of continuous combat function, that would apply in the first two. How does this law apply? This strikes me like naked self-defense. And how do you decide who an individual is targetable in the exercise of national self-defense? And I've nowhere where that question's been asked, and certainly hasn't been answered by the US government. And this is President Obama's guidance. Now, the debate that's going on in Europe is fascinating, right? Because largely the European countries were against the unwilling or unable till Syria came along. Well, let's correct it, till Paris came along. They're acting in self-defense. And a number of states, Belgium, France, one other, anyways, are involved in Syria on the basis that Syria is not exercising effective control over parts of its country. They used a human rights term, right? So on that basis, you could carry out strikes in Syria. Its active hostilities would be international humanitarian law. And what's happened before the UK Parliament is a debate, well, what if you're not in an area of active hostilities? Can you still use force? And this has started a fascinating discussion about whether you can use drones under human rights law. Well, you can kill people under human rights law, right? And this, again, this is a debate for human rights community, right? Because you'll hear many human rights advocates talk about human rights, the right to life being absolute. Well, just look at the European Convention on Human Rights. There's exceptions. And when countries govern, they have to use force, right? So the debate in the UK is fascinating as they struggle with whether you could ever use a drone strike. Okay, next slide. Okay, so that's targeting. Now we're talking about collateral damage. So how do you decide, right? So it's in the news every day. X number of civilians were killed in an airstrike. X number of civilians were tragically killed in a US Special Forces raid in Yemen, right? And so when is that lawful or unlawful? This is a fundamental difference between human rights law and humanitarian law. And it has its roots, once again, in medieval notions of just war theory. Okay? When it started out, it's the double effect doctrine. When this started out, the Christian church was exceptionally pacifist. Well, it's pacifist. You're a pacifist, you're pacifist, right? Okay? And the notion was you couldn't kill anyone. You couldn't put your life ahead of anyone else's life. But as they took on a governance function, this changed over time, right? And the theory began that you could kill someone else to protect yourself. Now, if you're governing, can you kill someone else to protect someone you're responsible for? Right? It's our notion of self-defense under human rights law, right? Under Canadian domestic law. Go look at the Criminal Code, the right to act in self-defense. Can you kill someone to protect property? Man's home is his castle. You're breaking into my home. Can I defend my home, right? Woman's home is her castle, however you want to phrase it, right? Now I'm a state, and I'm fighting another state. Can I use force against the other state for a good purpose to defend my citizens and happen to kill some of the citizens on the other side? Is that lawful? And the doctrine developed the double effect. It has two effects. The evil effect is killing the other civilians. The positive effect is you defend your own, right? Or you take out a regime that's horrendous on the other side. You intervene to stop human rights abuses. And humanitarian law, the law of armed conflict, allows that. And historically, that's what differentiates the law of armed conflict from human rights law, right? So how do you define that? Tremendous weighing of values. The value of human life versus, well, it's easy that way, right? It's human life versus human life. But what if you're in the military and your goal is to take that objective? What's the value of that objective versus the number of civilians that may be killed if I fire artillery at it? How do you weigh the military advantage with the evil collateral effects of uninvolved civilians? And we as humans have trouble with this, right? So at law, the test isn't proportionality. At law, the test is excessive collateral casualties. or civilian damages. If you go to the Rome Statute, it's clearly excessive. I mean, when the states had a second chance at it after 1977, 1998, they got to the Rome Statute, they reinforced it's clearly excessive, right? That's the legal standard. That may be not what the debate is in the news. So it raises the question of the role of lawyers versus public policy versus a whole bunch of things in politics, right? In terms of at law. So how do we as civilians, so one of the things we do is we turn to science. And when you read targeting doctrine, it's historical, and you go right up to modern day, there's a scientific, well, just think of when you read the news, surgical strike, right? I'm attacking a center of gravity. Well, that sounds science, right? Because these notions, the very same notions that brought the scientific revolution, the age of reason, brought the notion of humanitarianism. And the two carried along together. And its 21st century version, you get computer programs. So if you're in the US, they have computer programs that put in all the different permutations, combinations of angles of attack, weapons to be used, atmospherics, known intelligence that will give you a probable guess. I'm not so much a scientist, right? Probable guess of what the potential collateral damage is. Very insensitively called bug splat. Because when it came up on the screen, it showed a dark area where where the effects of the bomb would be. Right? But that doesn't answer the question, does it? Because still at its fundamental, it's a values thing. You're taking people's lives. Arguably not intentionally, but foreseeability, right? These are the types of questions that military soldiers at the lowest level up to the commanders at the highest level are asked to do every day when they're involved in armed conflict, is weighing that, right? It is a challenge. Let's look at human rights. So if you're a human rights advocate and you say, no, it's human rights law that applies to these levels of violence, what does that mean? Human rights law would never allow collateral casualties, right? And you can find lots of human rights writing and advocates that would say that. So let's go to Moscow 2004, the Moscow theater case. Chechen rebels, right, take the theater. They have a large number of women that were sitting interspersed amongst the hostages that were wearing suicide belts, right? And then the question was, how do you react to that? The Russian government pumped in an incapacitating agent, stormed the theater, brought the hostages out, 129 hostages died. Certainly human rights law would not accept that. European court did. That was an acceptable collateral effect. Wow. But the Human Rights Court, interestingly enough, the European Court of Human Rights said it'd be different if it was airplanes. Why? I mean, it's a challenge in all of this. There's a bit of ideological sort of resistance that's running through all of this. But I'll give you another human rights example. Okay, so this, ever since 2001, in Canada and US, NORAD has been protecting our skies, ready for another attack, right? Of planes going to be flown into some objective. When this came up in Germany, the case went before the German Constitutional Court. And they viewed it as assistance to law enforcement. And the German court struck it down under a human rights notion. And it struck it down under a number of views. There wasn't enough time to figure out exactly what was going on. There was the lives of the crew to be concerned about, the lives of the passengers, obviously. There wasn't enough information to be able to know for certain. And interestingly enough, from a human rights perspective, we cannot weigh the value of life in terms of numbers. Isn't that an interesting concept? So they struck down the legislation. But the plane's still flying. It's still going towards its target. And many people are going to die. So you have an interesting sort of human rights perspective of the European court looking at the Moscow theater case and another court in Germany really struggling, again, with the very notions that military commanders and soldiers have to make when they fire their weapon or ask for an airstrike or do whatever it is they ask to do. Okay, so you get the Israeli court looked at this and they came up with the idea of a zone of proportionality, right? So the court decides the zone, and then the commander gets to decide within the zone. So it never goes to, or well, it could go to 0 casualties, right? I mean, one of the problems with military doctrine, a lot of it's driven by the US, is they have a definition for high value target. There's no definition for medium value target or low value target. They anticipate to be in a war with a lot of high value targets. But if it's a low value target, how do you justify killing civilians? And so I would argue if it's a low value target, you may have to look at other ways, right? I mean, is it that civilian life is always below the military advantage? No. So that's one of the challenges there is for the law of armed conflict right now. In a counterinsurgency perspective, a key military advantage is not turning the population against you. What happens if you do? They stop giving you intelligence, and they start to attack you. And the next thing you know, you can't leave your base because they have IEDs planted all along the road, right? It's a clear military advantage. So you want to, as a form of military advantage, restrict the number of collateral civilian casualties. I'll put it even farther than that. They may be the local sons and daughters who have been recruited as part of the hybrid guerrilla organization. And so when you kill someone's son or daughter, they will not understand it was okay because the law of armed conflict said it was okay. Right? You alienate them. So the argument is to restrict as much as possible in a counterinsurgency, this type of, so you get a narrower notion of what is proportionate or clearly excessive. So that is a challenge. And the key is governance. And this is a challenge for military forces. Because if you're a young soldier and a Taliban fighter is firing at you from a local compound, you want to be able to stop it. And one of the things that works best is air power. Right? And you see this played out every day. If you look at obviously Aleppo, horrendous, right? Results in Aleppo. But not all uses of force that resulted in civilian casualties were illegal. Because the question is whether they were clearly excessive, dependent upon the military advantage that the Russian and Syrian forces were trying to attain. And this is going on right now in Mosul, right? And the Iraqi government has taken the view is we will go very slowly, try not to use air power going into Mosul. And this can happen for a variety of reasons. And one of the concerns is if they evacuated a city of 1 million, they couldn't look after the million evacuees. But it's gone very slowly with a constant struggle to use air power, right? To try to take parts of the city. And so this is what counterinsurgency looks like. And as a legal advisor, and as someone who may be working for an accountability framework, right? If you're working for the ICC, if you're working for a human rights group, your allegations have to be credible in terms of what you see as legal or illegal. And one of the interesting things that's happened in the post-2000 world is the notion of zero casualty warfare. And I look at it as two ways. One is, it came up in NATO bombing of Kosovo, right, in '99, which was the coalition planes were flying high, and the argument is they weren't taking any casualties, but they couldn't be as accurate, and therefore potentially there were more civilian casualties, right, on the ground. And was that lawful? Many pilots will tell you, depending upon the situation, it's far more problematic to fly low and drop your ordnance because you're too busy trying to stay alive to really target. But that's aside. That's what the debate was about, right? Depends on the mission. Now the zero casualty debate is there will be no civilian casualties. Zero. Or it's a crime. Interesting notion, right? Of how these armed conflicts, it's back to the notion of a very view of human rights-based notion of no civilian casualties. So next slide. So Michael Walzer, He wrote Just and Unjust Wars, and then this is a compendium of his later writings, where he sort of addressed the issue. So when you see the media and you see debates about civilian casualties, one of the things you have to look as a lawyer is say, I need to know more, right? I need to know why in those circumstances that level of force was used, right? For the military, there's sort of rule of thumb, which is you don't really know what went on until about the third report comes back, right? As the fog of war dissipates and people start to talk about what really went on, right? Or you get more information. It's a challenge. But to simply take the view you cause any civilian casualties is more likely than not in an armed conflict to be wrong at law. Now, you may have targeted the wrong person, and clearly that's problematic, right? But you may have targeted the right person and caused collateral damage that's entirely lawful under the law of armed conflict, collateral casualties. And that's the type of debate, and that's the reason why you need good objective investigations to determine what went on or not. The political debate will play itself out. The legal debate is different. That's not what lawyers are paid to do. Lawyers are paid to look at the law and the facts of how it unfolds. One of the challenges, one of Michael Walzer's observations that I've always enjoyed, he says, the lawyers have created a paper world which fails at crucial points to correspond to the world the rest of us still live in, right? And this is the problem of creating, we're in the law and order business, right? And we have to draw lines in places, right, to bring order to society. And we're in the rule business. And so society will chafe at those rules. And sometimes they will be hard to live in. The problem is when the law doesn't change. So, September 11th, 2016, I would say international law now accepts there's a right to act in self-defense against non-state actors, independent of whether they are tied to a state. The law has changed. It has been painful. There are still significant segments of the international law community that don't accept that. I would argue there are far more that do accept it. So we are in the middle of a process of change. And this isn't the only place, because I talked about the categorization of armed conflict. You know, there are, fighting non-state actors can take place in an international armed conflict. And the theories governing that are, so that's between states. So just all fight with non-state actors isn't necessarily a non-international armed conflict. So you have recognition of belligerent, AP1, controlled by a state, harbor or active support, the Israeli conflicts of international character theory, and then you have Dapo Akande's non-consensual crossing of a border theory that creates international armed conflict. Okay, so now you want to know how else. They could be an internal armed conflict, a spillover conflict into another country, extraterritorial law enforcement, that's Yoram Dinstein's theory, transnational armed conflict, Jeff Korn's theory, the Hamdan case, which is governing the US operations around the world, which is, if it's a state against a non-state actor, it's a non-international armed conflict, period, right? And another term I've run across, a multinational NIAC. Multinational non-international armed conflict. Two non-international armed conflicts beside each other. Come on, lawyers, help us out, right? But this is where the international community is right now. There isn't a consensus on this. We are in transition, and so we have a lot of theories. We have a lot of practice. But quite often, the two groups are talking past one another, right? And you know what practitioners largely do now, in my experience, although my experience is a little dated now, is we're going to call it an armed conflict. That looks like an armed conflict. It is an armed conflict, and I don't care how you guys categorize it. Yeah, there's special rules for international armed conflict. I get that. There's special rules for non-international armed conflict. I get that. The question is, what are the rules governing my use of force? that I'm allowed to use. And they're basically the same for both. And that's one of the debates that will continue on for some time. So we need to bridge that academic practitioner divide. Bottom line, though, is we need to privilege law enforcement when fighting a counterinsurgency. None of this will be won without, first of all, governance. And of course, the law enforcement piece is just one small part of that. But you will never win solely by law enforcement. You will have to turn your police force into an armed force, ultimately, depending upon the levels of violence. The other piece is the old notion of separating everything in that wheel is very problematic. Each of the bodies of law have important rules to bring, but they have to be applied together. And so if you go to the 2004 Wall case, right, the International Court of Justice, even with respect to human rights law, they said some matters could be exclusively law of armed conflict or humanitarian law. Some matters could be exclusively human rights law, or they could be regulated by both. And it's the regulated by both is what the reality of many of the operations we're involved in, and this isn't where the international community has looked. They're still fighting each other on trying to have, let me say, a lex specialis. Right? We're stuck on Latin. They all have to be applied in a holistic fashion. Thank you very much.
Okay, so thank you very much. Obviously, there's a whole range of topics that the lawyers are trying to sort out amongst themselves, not only here but internationally. Lots to debate. I just looked at the time, so it's 11:15. So I think we have some coffee and other things, but it's probably a good idea if we want to speed through. Professor Matthews is going to offer some comments about Ken's presentation here. So would you like to do that now, or shall we take a brief break? Okay, we could do that now, and we'll have a break afterwards. Yeah, exactly. Okay, we'll do that. Okay, perfect. Yeah, absolutely. If you guys want, feel free. So since you're not mic'd up, I guess you'll have to.
Oh yeah.
Yeah.
All right.
we don't,
Great. Thank you.
Unfortunately, yeah.
Okay, so yeah, get coffee or move around or leave if you want. But so thanks very much to the Nathanson Center and Otto for inviting me. It's a real pleasure to get to meet Ken, who's graciously allowed me to call him Ken throughout my remarks, and to have a chance to read the book and now to hear the talk. And also it's a great opportunity for my international criminal law students, many of whom are here today, to get to see this perspective and to understand how international criminal law is one subset of the many bodies of law that Ken mentioned is actually embedded in a much larger contextual framework of the law and of war in general. So I'm going to talk mainly about counterinsurgency and how that relates to Ken's what Ken says about that in his book, and then as a way of getting at some of the broader concerns, I think, that animate debates over the relationship between the law and war today in, I guess, the 21st century. So one theme that animates the book, and I think is a constant thread, is the need, according to Ken, to bridge this theory-practice gap. So Ken just ended on this note. And in order to do so, we need to refuse to adhere, according to Ken, to the dogmatic and exclusionary way in which traditional disciplinary boundaries have been constructed by international lawyers and military types alike around the various areas of law related to armed conflict. And so the regimes of international humanitarian law, international and domestic human rights law, and international criminal law, for example, are not self-contained and internally coherent bodies waiting for the right application in a given context. And so instead, according to Ken, the reality of the 21st century is hybrid conflict, right? Where a variety of legal frameworks can hold sway in overlapping and complementary fashions. So for example, notwithstanding the minutiae of doctrinal and jurisdictional legal wrangling over extraterritorial application, it's important for Ken that both the frameworks of international human rights law and also the dictates of the law of armed conflict, or as he calls it, international humanitarian law, are available in a given counterinsurgent force, right? In the same territory at the same time, depending on the tactical and operational requirements of the situation at hand, yeah? So I'm gonna quote just a slightly extensive quote from the book, because I think it eloquently puts together the dilemma that Ken wants to get at. So he writes, and I quote, "An emphasis on legal boundaries can lead to formal and sometimes rigid approaches to applying each body of law that does not always appear to work well in practice. It leads to the security personnel tasked with maintaining order having to fight literally at the limits of these legal boundaries. In these situations, operations are often conducted in a gray zone." I'm going to come back to this notion, "where international humanitarian law, human rights law, and domestic law intersect and overlap. This does not mean that the law is fundamentally flawed or incapable of regulating contemporary conflict. What's required is an assessment of why the boundaries and interpretational limits of these areas of law have developed in such a manner that the international legal regime appears to be so challenged in regulating contemporary conflict." And so I've tried to put a little bit of emphasis on some parts of that quote, but I think that really nicely encapsulates what Ken sees as the problem. So I agree with Ken that the formality and tradition that traditionally accompanies discussions of the applicable law in armed conflict is by and large quite unhelpful. So this is true not just in an operational setting, but I would also argue within the realm of academic literature and theory about war fighting in general. It's true that international lawyers concerned with war have created a discipline, whose internal economy admits disproportionately of bright line rule talk. So when law extends its shadow over war, we find that we are dealing either with civilians or combatants, with self-defense or aggression, with victims or perpetrators, with regular or so-called irregular forces. And the tricky thing, though, is that the modern law of war has supplemented what looks like a rule-based framework with a set of incredibly flexible standards, and this is where proportionality comes in. So we're expected to implement the rule that civilians not be either directly or indiscriminately targeted, but this rule depends for its enforcement on the very flexible principle of proportionality. We've just seen that the principle of proportionality requires, quote, "that an attack which may be expected to cause incidental loss of civilian life, which would be excessive in relation to the concrete and direct military advantage anticipated, is contrary to law and might even be a war crime depending on the circumstances." But what counts as excessive, as Ken just asked, and who does the counting? How many civilians is too many? And of course, there's no answer. But nevertheless, this principle in a sort of a strange circular fashion has to get reinterpreted into rule of engagement cards, right, that are then given to soldiers, right? So we've got a combination of rules and principles and translated back to rules that are supposed to give some kind of practical guidance. It seems a little bit nuts, I think. And so David Kennedy has described the paradox inherent in this sort of flexibility in the following terms. This is another slightly lengthy quote, but it's important, I think. And so, quote, according to Kennedy, "as the vernacular for making these distinctions has become more important, the distinctions themselves have come unglued. War and peace flow into one another, even as we continue to insist on the difference between civilian and combatant, battlefield, and everywhere else. We must recognize that humanitarian idealism no longer provides a standpoint outside the ebbs and flows of political and strategic debate about how to achieve our objectives on the battlefield. More often, I'm afraid, the modern partnership of war and law leaves all parties feeling their cause is just, and no one feeling responsible for the deaths and suffering of war. So good legal arguments can make people lose their moral compass and sense of responsibility for the violence of war." So I'm not, of course, suggesting that Ken invites us to, quote, "lose our moral compass and sense of responsibility for the violence of war." So it's quite the contrary, I think. The book is a carefully constructed work, in my opinion, that seeks at the end of the day to embed human rights-based principles in the very fabric of what it means to deploy political violence in the 21st century. The impetus is, as I take it, founded in a deep and practically informed concern for ensuring both positive substantive outcomes. So in other words, ensuring political settlements conducive to the proliferation of what we might understand as democracy and good governance, and also the moral sustainability of our armed forces as an institution and the individuals that then make those institutions up. But in what follows, I'm going to try and flesh out briefly what I see as some troubling quandaries invoked by this kind of approach. And so I'm most concerned with Ken's faith in the law itself, and in particular in the marriage of human rights with humanitarian law, to effectively and appropriately manage what he calls the gray zones created by contemporary warfare. So I'm going to try and do this, as I said, in the context of Ken's discussion of counterinsurgency. So as originally expounded in the 2006 U.S. Marine Army Corps Counterinsurgency Field Manual, Counterinsurgency provided a new language for low-intensity wars in which victory would turn not on kinetic defeat of an opponent's military, but on one side being accepted by the population as having legitimate authority to govern. So fundamentally, counterinsurgency warfare is a contest over political allegiances. According to this doctrine, by protecting civilians while providing development assistance, counterinsurgents seek to convince the local population of the legitimacy of their, in brackets, Western cause, thus isolating the insurgency's source of moral and material support. And the focus on good governance and population protection that COIN advocates, COIN is short for counterinsurgency, is supposed to incorporate human rights principles as well as law enforcement tactics as part of an overall strategy to win the political upper hand. So in part, this new doctrine was espoused, I think, in order to quell the persistent sense after 9/11 that the law of war was in a deep crisis and somehow therefore in need of radical reform in order to stay relevant and effective. So counterintuitively, and in reaction to the large-scale failure of Iraq and Afghanistan in the period between 2001 and 2006, counterinsurgency was a product of an overtly cooperative relationship, oddly enough, between the human rights and military communities in the United States in particular. And so in this sort of bipartisan effort, counterinsurgency dramatically departed from the neo-pragmatic discourse that had previously dominated and turned to human rights as the doctrine's actual centerpiece. So human rights was now a matter of both strategy and principle, according to COIN, where, as I said, civilian protection was understood as common currency not only among humanitarians and neo-pragmatists in the legal and military academies of the West, but also critically in the, quote, reasonable majority within the enemy's civilian population. This is all according to the manual. Most importantly, counterinsurgency doctrine shifted the ultimate responsibility for the war's success onto the local population itself, right? So victory was now defined by local ownership rather than merely the achievement of Western strategic goals. And as President Obama announced to the Afghan people in 2012, quote, as you stand up, you will not stand alone. So suddenly the war on terror was no longer a war that had to be won as such, and certainly not by the United States acting alone. So Ken rightly points out that the many critiques of counterinsurgency that have been launched since the winding down of ground operations in Iraq and Afghanistan have taken quite a bit of purchase. Given the scale and cost of those operations, appetite for further engagements with the level of boots on the ground required by the Iraq and Afghan surgeons has waned significantly. And as Ken points out, counterinsurgency itself was wrongly sold at the time as a strategy. In fact, it describes, and I'm quoting Ken, a form of conflict for much of the world's armed forces, no matter the preference of dominant military powers. So in effect, Ken argues, counterinsurgency is here to stay not because the US, Canada, or the UK wants it in particular, but because it just captures descriptively the nature of much of 21st century warfare. And in response, he argues that we need to beef up the complexity with which COIN addresses governance issues, right? And in taking governance more seriously, we're going to find out that a policing and human rights-based approach is often more effective than traditional military approaches. So Ken suggests that human rights law should be, and I'm quoting Ken again, used to interpret humanitarian law-based human rights norms. Where possible, this will mean that the capture, as he said, of enemy combatants is preferred to their killing, even though under a strict law of war approach, killing the insurgent would be legally permitted. So in helping us parse how this would look in practice, Ken suggests we focus on control of territory since, quote, the goal of insurgents is to physically control territory and to begin to establish the structures of governance. And he turns in support of this contention to the Israeli Supreme Court decision in the targeted killings case to find that whether to capture or kill should be determined in large part by reference to the criterion of control because, quote, realistically, a human rights-based approach that favors capture rather than killing is more likely to be instituted in a situation of governance. In other words, where a counterinsurgent exercises fuller control over a given territory. And for Ken, control is a concept inherently linked to the rule of law and order. In legal terms, the rule of law is the ultimate normative system of control, end quote. Using this approach, then, it seems that once control is established, the rule of law and human rights-based frameworks should mutually reinforce one another, creating the conditions for the growth of a system of what we might understand as good governance and thus contributing to the defeat of the insurgencies. But I worry about what this approach might take for granted as substantively satisfying the category of good governance, right? So in other words, what discursive and normative work is done by the notion that the rule of law is about controlling a population in a manner that is consistent with human rights principles? I think that's an open question that goes unanswered. Firstly, I worry that this approach glosses over the radicality of counterinsurgency's departure from the traditional law of war narrative. So it locates the conventional nature, the unconventional nature rather of counterinsurgency in its increased protection of civilians without also working out the potential downsides of this shift in doctrine. So we understand COIN as radical because it demands that the military assume more risk than it would under a traditional kill-capture paradigm, because it factors civilian disapproval into assessments of collateral damage, and because nation building requires an unprecedented level of cooperation between the military and civilian branches. But I'd suggest that the radicality of COIN lies not in the fact that insofar as it shifts the center of gravity away from enemy insurgents toward the civilian population, it undermines the civilian combatant distinction, actually, in potentially very serious ways. So, in other words, in making civilian hearts and minds the battlefield, counterinsurgents directly target civilian morale and political will. And where civilian allegiances and counterinsurgent goals are divergent, counterinsurgents will often have to strongly coerce civilian populations in potentially quite violent ways. And the fact that civilians are generally, though not always, targeted through political rather than lethal means doesn't detract, I'd argue, from their militarization under counterinsurgency today. So even if counterinsurgent operations were wholly devoid of violent tactics, which they never are, making civilian morale and political allegiances the primary target of counterinsurgent operations seriously threatens the principle of distinction. So I want to point out, though, that by saying that, I don't mean to be putting myself in the human rights camp in any way. The relativization of the formerly bright line distinction might be a good thing, might be a bad thing, depending on the circumstances. I think you need to have a fine-grained analysis of a particular context in order to make that decision. But what's important is that it's at odds with the human rights dogma that counterinsurgency purportedly incorporates itself, right? And so, in other words, counterinsurgency is not very transparent about what it does with the principle of distinction. But secondly, and this is my last point, I want to problematize Ken's favorable assessment of the targeted killing case itself as a way to productively think about, I'm quoting Ken, a more integrated normative approach toward the conduct of contemporary operations. So the Israeli court's embrace of human rights and its decisions on the use of force in the occupied Palestinian territories, and even the justiciability of these issues at the Supreme Court, is widely hailed by liberal legalists as evidence not only of adherence to, quote, the rule of law, but also the promotion of this idea on Palestinian territory itself. And I want to suggest instead that precisely this language of human rights in the context of a prolonged and brutal war of occupation not only normalizes the continuation of the conflict and the occupation itself, but does so on terms set by the dominant and oppressive state, namely Israel. So in using the language of human rights in the way it does, critical legal thinkers have long argued that the Israeli Supreme Court effectively denies responsibility for the concrete political effects of its decisions. And expanding for a moment the analogy to consider counterinsurgency theaters, more generally, these concrete political effects might be understood as including, for example, firstly, denying the legitimacy of the insurgents' claims to participate in the conflict in the first place, which we've allowed, and secondly, creating the impression that what we mean by good governance is the provenance of liberal Western democratic states whose courts are the arbiter of what counts as good war fighting in the 21st century. So I could say a lot more, but I want to end with this thought, that combining human rights with humanitarian law might actually do more to exacerbate the structural asymmetry of combatant situations than to alleviate it, which I think might risk further entrenching the sort of us-them imperialist, one might say, thinking that has generated so much of 21st century conflict to start with, right? So how did we get to the place where we have ISIS as Exhibit 1 today? So thanks very much, Ken.
Thank you very much, Professor Matthews. So I'm not sure if you want to respond to any of her comments, or if we can have you respond to a couple of things, and then we'll open the floor to questions.
Yeah, just a minute. I'm hooked up, I think, still,
yeah,
right?
that's right.
Yeah. No, great critique. Thank you very much for that. I just want to put in context the reason why I picked the Israeli court example. It's actually seen, as you know, as quite radical in humanitarian law terms. Because what it said as a matter of law is you have to apply human rights principles. And those principles being that you had to, before you made a decision to carry out targeting, it's the question of area of control, so could it be done safely in effect, and what was the risk to both the civilians and to your own soldiers. So that was the principle I was using from the Israeli case. And the context in which I was using it was, and I just put this in terms of length of time, I mean the history of the last 15 years has been 1 or 2 month conventional conflicts, so 1 month in Iraq, I don't know, a couple months, whatever, and 15 years of counterinsurgency. So, you know, counterinsurgency is here to stay, and the question is, if you are governing and taking all the other things that good governance means, which is far more than the use of force, but if you're talking simply about the use of force, the question is, how do you incentivize military commanders where at law they can use more force, incentivize them to use the more restrictive human rights regime? And so I think that's where the Israeli case particularly helps provide guidance. Because if you can exercise control over the area to safely carry out your operation, and if you've assessed the risk to the civilians if you do it, if you decide to capture rather than kill, as well as to your own troops to capture versus kill, then you have a policy choice that's entirely workable and should be privileged. If you don't control the territory, if you have to fight your way in to try to capture, and if you're going to put your own troops at risk and the civilians at risk in order to try to capture, then I think some serious questions have to be carried out by the military commander as to why they're carrying out that option. So I just wanted to put that in context. It's in a broader issue than simply the Israeli occupied territory debate. One of the challenges in this area is actually finding court cases that deal with many of these issues. And so, in any event, that's the context. But open to any questions as well.
Thank you. Do we have any questions from the? Okay, Professor Scott back here. I'll hold the mic over.
Yeah.
Great, thanks. Thanks so much, General, for the presentation. I mean, I totally agree with you that the almost extreme formalism of public international law has been a barrier to the proper grappling with a lot of these issues. And a more process-oriented theory of law does map onto the real-world process in which law gets reworked by practitioners such as yourself. And what I'm kind of grappling to ask is, starting in 2001, but I'm sure it didn't start even then, you already had Security Council resolutions talking about safe havens and things like that. The ground was being laid for different approaches. We already had use of force doctrine that recognized that something close to unwilling or unable actually triggered use of force breaches, but then you had the gap with the right to respond, and the Nicaragua case didn't help and all that. So if I looked at 9/11, as the formalist in me was saying, from what everybody knew at the time, the traditional Article 3G definition of aggression was probably enough. Sending by or on behalf of or substantial involvement, everybody thought there was enough of a connection between the Taliban and enabling Al-Qaeda, and that it kind of fell within still a fairly standard response, whether or not policy-wise it made sense. Very, very quickly, people sort of ignored, almost didn't even talk about that. They did jump immediately to the unable or unwilling ideas. And what I'm kind of wondering is, in the process that you found yourself involved in, how much self-consciousness was there of kind of being at the frontier of lawmaking through interpretation, lawmaking through pushing the boundaries, knowing that the only way this areas of law like this actually begin to crystallize as something different is that you, at some level, are pushing the boundaries to the point that you're maybe even breaking the law in order to change the law. It's standard problematics, right, that we have. So my question is, what kind of self-conscious reflection about role does Judge Advocate General or other legal advisors that you interact with, and whether or not that includes our own legal advisor in foreign affairs or others around the world, you at one point said, this is the critique of formalism, but at one point you said, this is what we have to deal with, this is what we have to use. And I'm wondering what existential process goes on where you say, you know what, this is the received law, this is the memo I have to write, versus I'm actually a norm-making actor. And that's more the role I need to play. I mean, how does that play out in the real world?
A really great question, because that very much embodied what, you know, from 9/11 on till I retired in 2010 was one of the challenges that we had. So, you know, and if one of the real advantages, what struck home for me, is actually the advantage of treaty law. So, because one of the first things that we certainly picked up was Additional Protocol 1, which, as you know, some of the major actors in the world are not parties to, at least the black letter word, although large parts of it customary international law. So I would pull out the part on taking a direct part in hostilities. So there you have black letter law, and Additional Protocol 1 was meant to apply to conflicts with non-state actors. So it has some relevance, although not the type of attack or not the type of actor that Al-Qaeda represented. But then the question is, what do you do? So you have this wording, you have the ICRC commentary, which is helpful, but you don't have much more than that. Maybe some writings by academics, but this wasn't a big the Both and Parsh book from the early 1980s or mid 1980s was a big help. And so you are going by principles, and you do realize that the question is, how can you do analogies? How far can you go? What's it represent? What's the historical approach that states have taken? You bring all that in together. It also brought in my office it also starts a lot of interstate discussion in terms of, and recently the UK Attorney General gave a speech on the use of drones, or well, actually the acting in self-defense, where he talked about the new idea of imminence. And he made reference to a process that was interstate and a continuing dialogue that's going on between attorney generals as trying to deal with the notion of self-defense. So there's a lot of that kind of discussion that goes back and forth. There's a lot, and when you're operating in a coalition, you know, at one point there were 50 some odd states operating in Afghanistan. I mean, some states are bigger operators than others, obviously, but there's a need in a coalition environment to reach a consensus or not as to how far you're going to go or not go. So all these dialogues are happening at the same time. We had a joke in my office, which was every day going to work was like having to write an international law exam with no time to study. Like, it was like, we had questions in the first 6 months was like, we had every hypothetical you almost could have thought of, you know, landed on our desk one way or the other. That said, there was reaching out to the academic community. And you saw post 9/11, and many of these working groups that I was involved in were a direct result of the changing operating environment. So the first international meeting I attended on international law was on the DPH study by the ICRC in 2000 and I want to say 3. And so they hosted a study of academics and state legal advisors to get together to deal with the notion of what it was. And so as a result, we sat down. Now, it took 6 years, but that also starts its own process of dialogue. Now, the interesting part of that study was that at the end, a number of us, who just happened to advise states, felt we couldn't sign on to it because it was too narrow in focus. in terms of what it would provide. But that sends a message as well, doesn't it, when you take that, right, when you take that state. But I was fully supportive of the ICRC doing that. The other piece was we took a view in our office to become strategically engaged. In other words, to start to write and write and place articles in journals of interest in that area, right? Because we felt there was a need to have the voice of the practitioner in the international dialogue. And so I would say all the things you mentioned. And the question is, when do you know you've gone too far? I feel very comfortable. That said, would I think it would go as far as a notion of self-defense like the US seems to have come up with? No. At the same time, when you sit down and look at where the international dialogue is on when an armed conflict starts, protracted armed violence doesn't match a Mumbai type attack. So that's where we are.
And if I could just quickly follow up, is that okay? So that's great. That's kind of just the real world of interactive engagement with the law. It's a great account. When you said you said let's take a more strategic perspective, and you talked about an earlier point about attorney generals talking to each other, which is kind of the classic Westminster idea of more than I think what goes on in Canada. And what I'm wondering is, just as to go back to your Latin, you said bellum ius in bello, the kind of interactive melding of those two areas is producing its own kind of challenges. I'm wondering how much of a boundary challenge it represents, at least in your time or since your time, what you've heard, for the respective roles of the JAG and the legal advisor in foreign affairs. And I'm just going to give you a clear example. I had the privilege to serve as an MP for 4 years. And at the time of the Harper government decision and debate to begin to provide some assistance in Iraq, and let's put it this way, it was palpably clear that the advice that the defense minister, Kenny, was belatedly relying on almost certainly was JAG advice, and that it looked like foreign affairs, now global affairs, hadn't been the lead agency on the issue of what would be the lawful way in which we could get involved. In fact, they missed the whole point, the formalistic point of having to link up to an invitation and maybe even send a letter to the Security Council as saying you're going to be involved in collective self-defense and all that stuff. And they scrambled. It took 3 days of Tom Mulcair and his lawyerly instincts side of just one small thing that he went after them on. There was a little bit of a sense that it had been kept as a closed shop inside DND as opposed to Global Affairs Canada being involved with the legal affairs folks. One would think in a system where, let's call it civilian predominance should govern the decision about whether to go to war, should have been the case. So without telling secrets out of school, because you were gone.
I have no secrets to tell, actually.
Yeah,
so that's easy.
You were gone by then.
I was gone by then.
The question is an appropriateness question.
Sure.
Is, as part of the enhanced need and role for your kind of lawyering and your team and JAG and that, is there any danger of a kind of reverse takeover of the legal interpretation apparatus? And I just gave you one example.
And one, I wasn't the JAG at the time. What I certainly can tell you is that we work very closely with our foreign affairs colleagues, very, very closely with them. I don't know what that happened in that situation. Lots of things happened behind the scenes none of us will ever know about in terms of what consultation there was and who or what part of the government might be a lead or not a lead. That's the challenge. So I mean, that's the only answer I can give is, is the question is the government takes its legal advice where it wants to, and there is a lot of the Americans would use interagency, we would use interdepartmental dialogue, and the various departments are headed by PCO, and then there's a PMO, and then you've got the Prime Minister. So just in the governance framework, it would be difficult to see how one legal advisor in the government would exercise that kind of control, I guess.
Any more questions from the audience? Okay, I've actually got a question for you, but
She did have her hand up over here. Yeah, okay.
First of all, thank you for coming here to speak with us today. I think we all really enjoyed it. I have a few questions, but I'll narrow it down to one. In regards to direct participation in hostilities, what do you make of the sort of unlawful combatant versus lawful combatant dichotomy that we've seen emerge in the American versus Israeli high court rulings? Whereas I understand it, the American ruling was that terrorists sort of reside in this legal black hole where they are covered neither by the rights that civilian combatants might have or illegitimate kind of domestic legal systems might offer them. Do you think that there is one that is perhaps more popular or widely used or pervasive in international law, especially in light of the fact that much of international law is grounded in practice as well as theory?
Yeah, in part it gets, I guess just to clarify, the question of whether there was a legal black hole in Guantanamo Bay was the U.S. Supreme Court took care of that in Hamden, where they, in some ways breathtaking judgment, said that where they sort of accepting customary international law of that this is where the state versus non-state is a non-international armed conflict. So you don't get to be outside that framework. But I think your question about lawful, unlawful, and it gets down to this problem of the binary, right, that I talked about. So if only lawful combatants are those that operate for states and meet the requirements of Geneva Convention 3, and everyone else is a civilian, does that mean that you can kill civilians? Now, I'm going to say this, but I want to really put this in context, because if you have a binary concept, the answer is yes. You can kill civilians who take a direct part in hostilities. The challenge would be, would you ever tell your troops you can kill civilians? Right? No. And so you've got, just within the framework of the law, you've got this challenge, right? Part of this is solved by the notion of organized armed groups, right, which is found in Additional Protocol 2. So even the laws struggle with this. And one thing I looked up once for an article is even within Additional Protocol 1, there's 5 different ways they talk about the participants in armed conflict. And in some cases, I think it's in Article 44, they just talk about persons. I mean, it isn't truly a binary even within Additional Protocol 1. But if you use the notion of organized armed groups and they're members of organized armed groups, that sort of gets away from this unlawful, lawful combatant notion. But underlying, I mean, there's also another sort of part of this dialogue is the people that fight for you are lawful and they're the good people. The people that are revolting against the government are the bad people, they're criminals, right? And the challenge that states have always had is that if you recognize them as lawful participants, even if they comply with all the rules, are you saying they're legitimate in the goals that they're trying to carry out, right? So that's the struggle that there is. And I just recently read about this in Colombia in terms of their dealing with the FARC. Was one of the challenges was President Uribe, who Santos is in now, he's the one that got the Nobel Peace Prize, brought the peace treaty in. Uribe, who was the president at the time, and Mr. Santos was the defense minister at the time. Mr. Uribe took the view that it was a war on terror, it was not an armed conflict. Because the notion, as reported, was if you call it an armed conflict, that alone legitimizes the other side. So these are narco-terrorists that we're fighting. they're real criminals. So that's a degree of the strength to which a state will go to the view that we're not involved in a war, right? It's a challenge. That said, states can take that view. They can absolutely say, I'm not treating this conflict as a war. So go to Northern Ireland, a 20-year conflict that, from my reading of the violence, and I talk about in the book, was clearly an insurgency / counterinsurgency operation. The UK government said, no, we're dealing with this as a criminal matter. The difference between the two examples is the UK government applied law enforcement / human rights-based notions of the use of force, which became problematic at one point because it started to get to the fringes of what you're allowed to use under a human rights-based force. In Colombia, the Colombian government was using airstrikes, right? So you've got this challenge of, if you want to go down the route of saying we'll apply a law enforcement approach, then there are certain rules that are restrictive, and it becomes problematic, obviously, not only for your state, but it becomes very problematic for the soldiers you're asking to use force on behalf of the state if you're asking them to use force that's outside the framework which you're declaring to the world operates. Another example is, in practical terms, are we at war with Al-Qaeda and the Islamic State? They're at war with us. So far, the only two things I've been able to find is a quote from both Prime Minister Trudeau and Stéphane Dion when he was foreign minister that said we aren't in a war. But let's say we were, okay, at law in a war with the Islamic State, and they carried out an attack in Canada. Would we have to respond with armed forces means? Maybe, maybe not, probably not. Because our military forces are very capable, our intelligence forces are very capable, and the first responders are likely to be police. So, until you get to the point where you're going to call in the military under the various regimes that you have, and even then you can call them in under a law enforcement framework, even in the content of what you might take at law as an existing armed conflict, you don't have to. And so my theory is, if you don't have to, and the law enforcement people approach can work, that's the one you should use as a matter of policy, always, right? So that's sort of where I am when I say privileged law enforcement. So it's not just counterinsurgency, but even within countries that have well-developed security systems. So this is the challenge in Iraq, which was mentioned by Heidi. You also have counterinsurgencies where it's a foreign government that's trying to carry out the counterinsurgency. 20 years, Northern Ireland if you've ever been to Northern Ireland, it's very similar to the rest of the UK, but different, right? So it's culturally different. There's dialect, linguistic differences, accent differences, whatever. But it's in many ways, similar to the UK. Very effective police force, a prison system, functioning courts. The military was called out, but it's still initially a military primacy operation that turned to a police primacy operation, took 20 years to end. Iraq, foreign states trying to carry out an incursion. You don't speak the language, you're not culturally, linguistically, you don't have the intelligence gathering capability, and so if you're going to win an insurgency in a foreign country, you have to reestablish the security services of the foreign country in order to do that, right? And so that's sort of, again, establishing the police force. And the police force, one of the challenges of this type of warfare with insurgent groups, and the mixture with crime, and it also comes out with drug cartels, is they're very much organized themselves like gangs. And so one of the things you'll find a lot of literature of police forces, when they approach groups like Al-Qaeda, and there were a lot of police forces involved in counterinsurgency in Afghanistan and Iraq, and clearly there are in Central and South America for drug cartels. Okay, when you approach gangs, it's a very similar intelligence picture that you get as to how these organized armed groups, at least initially, organize themselves. And so you get arguably, a much more accurate and useful intelligence perspective from a policing type framework than you do from a military type framework that's focused on conventional forces and wants to count the number of tanks, the number of aircraft, and all of that. That's why I say it's an operating environment in which law enforcement has to be privileged. Okay. That was a long answer, sorry.
I think we're just about out of time. So again, I wanted to thank you once again for coming on behalf of Osgood and the Nathanson Center.